Right. Good afternoon, everybody. Thank you all for turning up on time. Those of you who turned up at 6 o'clock to be on time were very impressive. I hope you enjoyed 3 cups of tea and all the biscuits. This is the first time I've been in this building, and it's really a very good venue, I think. This evening's theme is international issues in children cases, and the aim is to not cover the whole ground, but to take 2 quite important but completely different snippets within that overall jurisdiction and look at them in some depths. This is an event put on by Bloomsbury, who are new entrants in the family law publishing world. There was a rather odd process 18 months ago when Butterworths bought Jordan's, and suddenly it was thought that was a monopoly, and so some works were hived off to a different publisher. And Madeleine and I, who work on Gershman and McFarlane, are extremely pleased that our other publisher has been Bloomsbury. We found a very welcome home here, and I hope those of you who use children law in practice really haven't seen any change in the quality of the product and the service. Bloomsbury hit the ground running, and they're commissioning other works. You'll have seen the flyer in your pack, which I've left behind, for the book that Kathryn Cronin's written for them on precisely the topic we're dealing with this evening, first of all from her. And they're keen also to commission other works. So if you feel you've got a book bubbling on in the back of your mind, do get in touch with Bloomsbury. They've also obviously got Peter Duckworth's book on matrimonial finance and the family court reports. And from that little suite, as they will no doubt say, of books, they hope to become a major family law publisher. Alongside that, they're hoping to hold a major conference in the autumn. And in your goodie bag, you'll find a survey, and it would certainly help them to focus the event they put on. If you could spend 2 or 3 minutes filling that in, just to let them have your views on that project. So enough of that. There's no housekeeping announcements except that the 2 fire exits are here and there. If the fire alarms go off, it's for real, and there'll be instructions spoken by somebody to tell us what to do. But I think, a word to the wise: get out of the doors as a first start. So the timetable for the evening is to have 25 minutes each from our 2 speakers, and then hopefully about 10 minutes or so at the end for questions and answers before we adjourn for what's called drinks and nibbles outside. So without further ado, I'll invite Kathryn Cronin to come and speak to us. I think everyone in the room will know Kathryn as an expert in immigration law, who has been kind and canny enough to share her expertise with those of us in the family law world in a whole number of cases. And she's going to talk about how to deal with immigration problems arising from family litigation. I don't know whether she knew the weather forecast, but she's based at Garden Court Chambers, which is the next building to here. So unlike some who come in looking as if they've been hosed down, she's fresh and dry. So I'll hand over to Kathryn now and ask her to speak on that topic.
Thank you very much for the introduction, and can I just say that although I would love to say that the book on child migration is written, it's in fact a work in progress. So it's been a fairly difficult gestation really in terms of just collecting the array of information that is needed in a book of that kind. I think that what inspired the book was just the sort of work that I get asked to do endlessly, and the very clear knowledge that there are just so many cases in the family division where immigration surfaces in one form or another. You certainly get the array of cases where people have actually initiated the family application expressly to get an order that is essentially an order that is needed for a visa application. And those, and that is because many of the criteria in the immigration rules, and also the policies that the Home Office has devised require people to have particular types of family orders in order to establish the sort of family relationships that base their visa application. So, for example, the recognition of an overseas adoption is a requirement in order to bring in an adopted child if the adoption is not automatically recognised under the provisions in Section 66 of the Adoption and Children Act. You've also got essentially requirements for things like a valid divorce, and so you may have to get various declarations in the family division. And the other sorts of cases are those where it's not a particular criteria for the visa class, but certainly some of the evidence that you may well derive from the family division is going to be enormously useful potentially for your visa application. And those cases are really significant. You get your FGM cases now, your forced marriage protection. You have, again, some of the domestic violence is a very common application made with an eye to a visa application that is going to be put forward by the visa applicant, and also the parents seeking contact with their children as part of a family life claim. So those ones again have immigration issues embedded in the case, if not the express focus of the case. And then you get other cases which may be private or care proceedings where immigration issues arise in the course of the proceedings, generally as part of the placement decision for the child. And so you get very often issues arising because the good enough parent is a person who is here with irregular immigration status, or you may have a carer abroad or potential carer abroad who you need to get a visa in order for them to be brought in for assessment. Or you have an EU national who's economically inactive, and so their immigration status comes up for consideration because they're not covered by free movement rights under the EU directive. And in those sorts of cases, what you're looking at is not just potential immigration status and whether or not the parent and child can remain here, but also whether the parent and child can remain here and access welfare benefits, and in particular housing assistance and housing benefits. And increasingly with the numbers of cases where you're considering moving a child into a different jurisdiction, and in particular placing a child abroad for adoption, or a child abroad with an SGO, again, the immigration issues arise not in the context of necessarily the UK, but they definitely arise in terms of whether or not the child can enter and settle in the country where the proposed carers live. And so these, so many of the cases that we get asked to advise on are in fact cases about foreign law, and what is needed is a Polish or a German or a Sri Lankan or Indian lawyer, rather than necessarily a person who knows UK immigration law. And then the only other cases that I just briefly allude to are cases that you don't see so often now, but I think are still somehow in the system, possibly at a first instance level, are cases where there's really no genuine dispute or no real benefit to the child from the family application, but you have a parent who is desperate to delay or prevent removal, and so they are seeking some sort of family order in order to, as I say, to delay or stop that. And the other line of cases, which has been going on now for really 20 or 30 years, are those adoption cases where you have an adoption by a British citizen and the child will obtain British citizenship by the adoption, and you have a whole history of the Home Office intervening, of the Secretary of State intervening in those cases, seeking to stop the adoption on the basis that it is somehow undermining immigration controls, to give an adoption order in those particular cases. And the demarcation in those cases is very clear, that the family court looks at its own jurisdiction and the issues invoked in its jurisdiction, rather than necessarily acts as a policeman for the Home Office. What I wanted to focus on this evening is the arrangements that have now been in place for a few years, but are not necessarily very well established, and those are the arrangements for some sort of cooperative working either between parties in the Home Office or the Court of the Home Office, or indeed the parties and the immigration tribunals. And the first point, I think, is really an important one to think about, is whether or not you should contact the Home Office, and if you do, the sort of information you might disclose to the Home Office, and the sort of information you can generally succeed in getting from the Home Office. And all of you will be familiar with the protocol, the EX 660 forms that allow you to seek information from the Home Office. And in my experience reading them, they're very spare replies in most cases and barely informative. And it always seems to me that the most sensible way of dealing with a case is actually for somebody to make an application for disclosure of the Home Office file of the particular persons, and get the court to direct that those files are disclosed to the parties by a particular time limit, because it is embedded in the immigration file and all of the documents pertaining to the case that one can see the sorts of information that you need to understand the history, the immigration history, but also the potential options for the future. And I think in all of these arrangements about contacting the Home Office, you do have to think about privilege. It sometimes shocks me, really, to just see how dramatic can be the difference between the history given by an applicant in their immigration case and the history given by the same applicant in their family case. So they're often diametrically different accounts. And I think that it behoves everyone, where you have got that immigration context in the case, and you may have to deal with the Home Office, that it's important to warn the client that this sort of overture to the Home Office is going to bring to light stories and accounts and witness statements that they've made in their immigration cases. And the sort of consequences of that, because now the Home Office is really vigilant about and really rigorous in either prosecuting or removing in cases where you have a marked immigration deception, and it can certainly affect any future application that the person might make. The other thing that I think about involving the Home Office is that there are some relatively recent cases where you've had a really helpful involvement of the Home Office. So in some cases it may be sensible to invite the court to make a direction asking the Secretary of State to consider intervening and becoming a party, or at least intervening and making submissions and making information available. One of the cases that I mentioned in the short notes that I did for today's proceeding is a case of KB and RJ. It was a parental order case where you have a child stranded in India, where the parents, without any legal advice, had made completely misconceived entry clearance applications, and the child had been repeatedly and properly refused. And you have a judgment by Ms. Justice Russell, where she has indicated that really the court shouldn't make a parental order unless the parental order reporter has had an opportunity to see the child here with the parents. So if you have the child stranded abroad, you have a limping case in that sense, in that there's no capacity to get the welfare part of the case dealt with. And in that case, Mrs. Justice fourthly agreed to set a preliminary hearing, and to have that preliminary hearing dealing with all of the issues about the Section 54 of the human fertilization and embryology act, to see whether or not those criteria were met, and to give a short extent a set of findings about those criteria being satisfied, and then adjourning the final hearing and the welfare assessment to a fixed date, and allowing the Home Office to have the time between those findings being made and the final hearing set to reconsider whether or not the child ought to be granted entry clearance. And in each of those cases, some of which I've been involved in, it has worked wonderfully. The Home Office has been very engaged and cooperative. The various directions have been made about the Section 54 criteria are met, and the visa duly granted before the final order, so welfare report can be undertaken. And it seems to me that case and others that you can see is that the Secretary of State is comfortable if her jurisdiction is recognised and respected, so that you do have, in a sense, this very clear canvas in which each of the parties, to get to the final order, you all have a different part of the exercise to wrestle with. But there isn't any straying into the part of the jurisdiction that belongs to, in this case, the Secretary of State. And the other case, again, a recent case where these issues arose is in the context of a wardship case where you had an unlawful retention of a child who, the child and mother having been granted refugee status on the basis of claimed domestic violence. And then you have the father coming to this jurisdiction seeking to ward or in fact warding the child and seeking an order that the child be returned to the home country. And again, on the direction from the Court of Appeal in the case of H, the Secretary of State was invited to participate. There was the Joint Council for the Welfare of Immigrants was also a party, and of course the parents and child were all represented. And the issue for the court was whether or not the child's refugee status was a bar to his removal. And the consensus view of all of the parties was that it is a bar to removal. But that again, you have another hearing. So the Secretary of State is there. Most of the submissions of the Secretary of State were accepted by all of the parties as well as the court. And what you then set up is a further hearing where the facts upon which the refugee status was given may well be contested in the family court, and the court may take a view that the mother has told lies and that there isn't in fact any risk to either her or the child in the home country. But then again, the consensus view was that it would then go back to the Secretary of State to consider revoking the refugee order, the refugee status decision, and if there was no revocation, then again the child is not able to be removed. Again, I say that one of the reasons why these things are really significant is that the Secretary of State's decision about refugee status is not simply a decision about which of the parties, whether the mother is in fact telling the truth, but you have quite a different analysis in a refugee processing system than you have in the family court. You first of all got a much lower standard of proof, so you don't have balance of probability. You have a real risk of harm. And the most important decision, or the most important component of that refugee decision by the Secretary of State is the decision based on country evidence, which is rarely accessible and available in quite the same way to the family court, that if there is a risk, that the child and the mother can't get effective protection from their country of nationality. So it's really a decision that is within the expertise of the Secretary of State, because it's not simply about which of the parties may be giving a truthful account, but whether or not a particular country is affording the appropriate protection to one of its citizens, and that is very much a question within the clear bailiwick of the Secretary of State. The other reason why I think you will find in future the Secretary of State pulled into cases. And at the moment, the only cases in which there is a practice direction for the Secretary of State to be invited to intervene is in adoptions where the child will obtain British citizenship. And that is because those family cases have the unusual effect of changing the civil status of the child and making the child no longer subject to immigration control. But one of the features of legislation in both the Immigration Act of 2014 and then again in 2016 is to set up what Parliament has consistently called the hostile environment. And it is a hostile environment that is beginning to have, and will in future, if it is all brought into effect, will have a significant impact on family cases in the family court. Because what this hostile environment does is that anyone who needs leave to remain and doesn't have it, and there can be a whole lot of reasons why you don't have leave. You can be born in this country and not British. You can be a child brought in as an infant and whose parents didn't ever get their status regularised. You could, of course, be somebody who made an application and the Home Office has treated it perhaps wrongly as invalid, that you were there then without leave. In all of these cases, there's a whole series of services that are going to be denied to you. You can't have a bank account, and your bank account has to be closed. You can't drive a car. You can't take any employment. And more particularly, your landlord or your co-tenant is liable to criminal prosecution if they continue to lease or allow you to remain as a rental in their property. So you are going to have people rendered homeless, and we're already seeing it in some of the jurisdictions around the country where these rental provisions are in force, where people are being made homeless not because they can't afford to pay rental in the private sector, but because their immigration status doesn't entitle them to rent from anyone other than a local authority. And so you will have the local authority forced into housing, or, and what my prediction would be, you have a whole lot of family cases in which, as a preliminary matter, you're going to have to invite the Secretary of State to be at least a participant briefly in the case in order to permit the person to rent or to be a lessee of a rental arrangement during the term of the family proceedings. So this enmeshing of these family and immigration issues and family and immigration decision making, I think, is going to be loom very large indeed when all of these hostile environment provisions come into force. The further question, I think, to consider in these family cases is not simply to whether or not you deal with the Home Office and arrange to either provide information to the Home Office or seek information from the Home Office, but also whether or not you involve the immigration tribunals. And in the paper I mentioned a number of cases. In fact, Lord Justice McFarlane was one of the key judges in two of the cases where he sat with the then president of the Immigration Tribunal, and they gave guidance on how to deal with these intersecting cases when you have the same family that has got an appeal in the immigration tribunals, and they're also litigating in the family jurisdiction. Now, these are very often cases where the person is facing deportation or removal. They have a genuine and hopefully proper desire to get a contact order with their children. And of course, getting a contact order can be a basis upon which they are entitled to then get a visa and remain in the UK. So it is an important immigration right, it's an important family right. And there was no proper arrangements for these cases. So one of the key parts of the guidance was to say that that the immigration case should go behind the family case. So it should be stood out, and the hearing on whether or not the parents should be removed should await a decision on the family case as to whether or not a contact order should be made, and indeed various findings about the child's welfare and best interests. And that tends to happen. That's fairly, unless the immigration tribunal considers that the case is entirely without merit and was just brought in as a sort of a mechanism for delay, then they will almost certainly stall the case to await the decision in the family matter. The other part of the guidance, it sets up arrangements for disclosing information across the two tribunals. And in my experience, looking at both jurisdictions, there's very little of that exchange of information. And I have actually rather more caution about whether or not that is appropriate. Certainly, as a lawyer, I think you've got to really make the decision as to whether it's in the interest of your client for some of that information to be exchanged as between the two jurisdictions. So you may well have applications that exchange should not be made. But I also think that that in other cases that exchange of information is going to be extremely helpful. And probably the best way of dealing with it is to leave it to the parties to decide themselves whether or not they want to ask a court in the family division to agree for certain of the documents to be disclosed either to the Home Office or to the tribunal. But to have the decision made, I think, by judges, and as in communication between judges in the two jurisdictions, I think potentially could appear to be a problematic exchange and communication that's outside of the control of the parties. It seems to me always that people working in the family division ought to be, particularly where there is an immigration side to the case, need to be alert not simply to the issue of disclosure, but also to the question about what you put in a preamble to an order, or whether you ask the judge to make a short extent judgment setting out findings, so that they can form part of the deliberations in the immigration tribunal. In the case of Mohan, that went to the Court of Appeal, and which looked at these two tribunal cases, RS and Imago Boateng, where the guidance was given, in Mohan, the court made the observation that, first of all, the guidance is set down by the two judges who have considerable experience in each of the jurisdictions, but also the family court is in a much better position to deal with issues about the welfare and best interests of children. The immigration tribunals are really handicapped in the resolution of those issues, and the current president of the Immigration Tribunal has said repeatedly that you have got to have an utterly rigorous, detailed evaluation of the sorts of matters that are germane in family jurisdictions, because those are the matters that are key matters in terms of evaluating welfare and best interests. And you have exactly the same duty imposed on the Secretary of State as you have on all local authorities from the Children Act of 2004. So the supporting and promoting welfare are identical obligations in both jurisdictions. And so those findings from the family court, where they've heard from both parties, where they've heard from professionals, where they've got professionals who've got considerable experience in child welfare, child development, child attachment, all of those things that are key issues in a removal or a leave to remain application, those are much more sensibly dealt with and much more fully exposited in family cases. And certainly if those findings and the evidence on which they're based are made available in the immigration jurisdiction, in my experience, they always have a considerable weight, not simply for the tribunal and the judges in that tribunal, but also for the Home Office at first instance. And their own policy suggests that these things should be given considerable weight. Now, I just wanted to really just have some suggestions for the sorts of things that lawyers in the family cases need to be alert to when you've got an immigration matter that is potentially there or is actually on foot in the immigration tribunals. I think that there is going to be a really significant issue for people post-Brexit if indeed people, we're no longer part of the free movement arrangements of the EU. And what I think Brexit brings home, certainly to lawyers in the immigration jurisdiction, is the real importance of giving proper consideration to the nationalities that a child may have and that a child may wish to exercise when they are adults. So if you have a child born in this country who's got parents with foreign nationality, in all probability the child will have inherited that foreign nationality by descent. And again, in my submission, and I try to advise this in many of the advices that I give in the family matters, is that it's incredibly important to not only think about the nationality and take advice about which ones may be available and accessible to the child, but also how to access them. And in many of the citizenship by descent, you need to register the child's birth, and sometimes register the child's birth with their consulate within a particular time span. And if you don't, the child may in fact lose the capacity to have that citizenship. You also have to check whether or not the country, the child's citizenship by descent is from a country that allows dual nationality even while you are a child. So many countries allow children to hold dual nationality and then requires them to elect when they turn 21. But get those nationalities for the child so that when they do turn 21, they have the options to adopt the civil status that is commensurate with the future that they want to live. And it's also important, particularly where children are being removed from their family, that you get them the sort of documents that will allow them in future to prove their citizenship. So it may be the birth certificates of parents. So in care proceedings, it seems to me that in care plans, there's a whole lot of things that are never put in a care plan that really ought to be there. And post-Brexit, when we're much more alert to the need, the rights of travel and the loss of rights to travel, things like getting the birth certificates of parents, getting notarized copies of the parents' passport. These things can be held for the child so that at the age of 18 they can apply for a passport in whatever country they can assert their nationality. You need to regularize the child's immigration status. And I know from my chambers that there's been a number of cases where they have sought damages against local authorities for failing to regularise the immigration status or regularise the nationality status of children while they are children and while they are either looked after or children in the care system, because that failure can have a very real impact in adulthood, with the child being liable to be removed when they turn 18. And it's important for local authorities and family lawyers to know that there is a provision in the British Nationality Act, Section 3(1), that allows the Secretary of State to register any child as a citizen if he thinks fit. That is the wording in the provision. So it's a very broad, it's one of the rarest of provisions in nationality and citizenship and immigration law that preserves this very untrammeled discretion of the Secretary of State to just call someone a citizen. Those of you of my vintage will remember the Zola Budd case, when she was given citizenship in order to be able to run barefoot in the Olympics. But in any event, those are very significant mechanisms for children. And under Home Office policy, they suggest that children in the care system can be registered as British citizens if social workers indicate that they consider the child's future to be in the UK. So you have
you have very many of these really vulnerable children, and you have the mechanism through a care plan to consider a child's identity rights, their civil status rights, and the sorts of procedures and mechanisms that that really ought to be put in place for them. And just before concluding, yes, there's two more things that I wanted to say. Is that one other reason for getting this done for children, while they have the advantage of local authority involvement, is just the cost of these immigration applications. Currently, if you were two parents and two children applying for leave to remain in the United Kingdom, you would probably be spending £7,000 to make your visa application. And because the child is also the children whose cases are not considered in any sense separately from their parents, nevertheless are charged the full visa application fee. And they also have to pay £200 per year for both children and adults as an NHS surcharge. So if your visa is for 5 years, you pay £1,000 for getting a visa of that length to cover the anticipated NHS costs for that period. So to have the local authority engaged and getting those applications for a child as a child, and while the child is in their care, can mean that the child has got secure status, that their parents, even if they were returned to their parents, that their parents simply couldn't afford to make that application on their behalf. And a recent study by Islington Law Centre just showed the large numbers of these children brought in to this country as children, but who have irregular and unresolved immigration status, who are really vulnerable to removal at the age of 18 because no one has stepped in to regularise their status during their infancy. And then the last thing that I wanted to mention, as the other area where you do get a lot of crossover arrangements, are in trafficking cases. And again, that is a case where you have, first of all, an obligation to refer any child that's considered to be a potential victim of trafficking to the national referral mechanism, which is, if the child is a foreign child, is the referral mechanism in the Home Office, where their status as a victim of trafficking is to be determined. And again, you see in numbers of the care cases, actually I must say I get enormously impressed in seeing the trouble that local authorities are taking with trafficking victims and the efforts that they go to provide the sort of, not just the protection, but also the recovery arrangements that many of them need if they've been actually exploited or abused as a trafficking victim. But the other thing to remember is, again, that as a trafficking victim, there is a mechanism in the Anti-Trafficking Convention, the Council of Europe Convention, that has become part of Home Office policy for those victims to be granted a term of stay or a term of leave. And generally the Secretary of State's view is that unless there are adequate care arrangements in the country of nationality, children are allowed to remain here. They're given leave to the age of 17 and a half, so that in that last 6 months, the Secretary of State can consider whether to allow them to stay, and if not, have them ready to be removed on the dot of turning 18. So it's a very, it's a harsh process for these children, many of whom have had all of their infancy in the UK, and whose capacity to remain very often requires the involvement and assistance of lawyers and social workers and other professionals who can indicate to the Home Office as well as to a family court the sort of attachments, the sort of identity rights and interests of the child over that extended period of time. I think I will finish there. And we can...
Thank you, Kathryn.
30 minutes was rich and valuable and lucid, and I can't think how it could have been better structured or more useful, certainly for me, and I hope for all of you. And I think you could have gone on for a lot longer, and we'd all still be lapping it up. So thank you very much indeed. Reference to Hirschman and McFarlane and a Bloomsbury event. The last time Madeleine and I were together was for a 25th anniversary party for the book Hirschman and McFarlane a couple of months ago. And I mentioned it because there was a surprise birthday cake made in a facsimile of the book. And this has recently been on Extreme Cake Bakers on Channel 4. So that now when I go into Pret a Manger on Fleet Street, they all go, hi! I've seen you. So you want to see it, you have to go on, you've got to be careful with this. It's on the iPlayer for Channel 4. I typed in 4-player. The see again thing for Channel 4. Episode 4 of Extreme Cake Baker, and you can see this cake and you can see us cutting the cake. That's a way to introduce Madeleine, and before I did ask her to come and give her talk, it's a moment for me to say that Madeleine's now been my co-partner, entirely equal partner, the two of us on our own, writing the updates for Hirschman and McFarlane for over 10 years now, and the book's 25 years of age. And if there was any justice in the world, it would be called Hirschman, McFarlane and Reardon. She and I worked very well together, I think, and it was a very, very happy and lucky day for me that I met up with Madeleine, and I look forward to many years working together with her on the book. You will know her as a junior barrister at 1KBW who has a broad practice across family law, quite a rare thing now to be doing the money cases, the care cases, the private law cases and the international children cases. Recently appointed a recorder, and she's now going to talk. I thought when I first saw the programme for this, should I medicate my relocation case? It did sound attractive to the judge. But should I mediate my relocation case? So I'll hand over to Madeleine now to ask her to tell us about that.
Thank you, Andrew. After Kathryn's extremely informative talk and these essential notes, I'm very conscious that what I'm going to say is probably not going to tell any of you anything that you don't already know, and involves very little actual law. I'm going to be talking about relocation, those cases where a parent wants to move permanently with a child to a different country. I'm definitely not going to be giving you the case law on relocation, so I hope you haven't come for that, but looking at this audience, I suspect you know what you're doing in those cases and don't need any of that anyway. What I'd like to do is to start a conversation about whether we could or should be approaching relocation cases in a slightly different way. So, explain what I mean. I've been instructed to attend many first hearings for Hudras in international relocation cases, and over the years I've picked up that they've got a few things in common. The hearing is generally pretty short. Often you have an agreed order and you're back in chambers by 10:30. Often, relative to other cases, the hearing is happening quite shortly, maybe just a few months after the separation. The parties probably won't have been to mediation, even if one or both has done a MIAM. And at some point, someone, often it's me, will use the word binary. Now, that is because the received wisdom in these cases is that these are cases where there are only two possible outcomes, 1, 2. Therefore, the thinking goes, there is no possibility of compromise. And in a sense, that's true, because if parent A has her heart set on going to Australia and with the children, and parent B is absolutely adamant that the children are best off in London, the midway is not Hong Kong. There is no possible compromise in that sense. But what I'm going to be saying this evening is that we need to be a bit cautious about approaching every relocation case that walks through the door in that way, as if there are only two outcomes and we are going hell for leather for whichever it is that our client is proposing. Now, just to be clear, I'm not talking about what you do once you're in litigation. Once you are in the court process, and by that I mean in any document that might ever make its way anywhere near a judge, so correspondence, the lot, you are of course not going to be presenting your client's case in an equivocal way. So for the relocating parent, this is the case that you're presenting, and for the parent left behind, that's the case that you're presenting. I'm not saying that there is really much scope for doing anything different. And that's how it's going to look to the judge, who may or may not accept the cases as they are being put, but at that stage, at final hearing stage, really is making a binary decision, that one or that one. What I'm talking about is the period leading up to the litigation, and even during the litigation itself, what's going on behind the scenes between you and your client and between the legal team on the other side and their client. What is the reality in relocation cases? The answer to that is we don't really know. They are more than almost any other case, a giant leap into the unknown. Is it happy ever after for the parents and the children who relocate, or is it a rather more bleak picture? There has been along the way some research, and Alison Chalby from Reunite was telling me this evening that they have some more research in the pipeline. You'll probably know about Dr. Madeleine Freeman's paper in 2009, and Rob George did a review of court files and relocation cases in 2012. That research so far has presented a mixed picture. It is, of course, based on quite a limited sample, because we don't routinely follow the outcomes of these cases after the order is made or refused. So the research that is done is based on interviews with those parents who are still around, still contactable, still willing to speak. And of course, it has to be acknowledged that quite often the parent who wants to speak to the researcher is probably the parent who is more dissatisfied with the decision. But what comes out tentatively from that research is that, firstly, the often problems in maintaining contact after a relocation takes place, and the dissonance between what is presented as a contact plan and what actually happened. And also the mixed feelings of parents after orders have been granted or refused, in contrast to the binary cases put before the court. I will be absolutely devastated either way. So I picked up something interesting that was said by one of the mothers interviewed by Madeleine Freeman, who'd been granted permission to relocate and then regretted it. And she said that she wished that instead of the assumption being happy mother leads to happy child, someone had looked at it the other way around and said, well, shouldn't it be happy child makes happy mother? And what she was saying was that after her relocation, she was stuck with a pretty miserable child, and that wasn't good for either of them. So it gives a lot to think about, the research that's been done. We don't have a comprehensive understanding of outcomes. As practitioners, we often don't find out what happens after our own cases conclude, but sometimes we do, and I thought I'd share a few from my experience. To avoid identifying anything accidentally, I've changed some of the countries, and I'm sure I've been against some of you in some of these. So if you think you recognise it, you might just, don't go sharing what you think you might have picked up. So Riem, Canadian mother, British father, family living in the UK for a long time. Mother wants to relocate with the children to Canada. Father wants children to remain in the UK. Outcome application is granted, so off she goes. 6 months later, that was what was happening. So she's homesick for the UK, children missing their father, and mother's desperate to return. Next one, repeat. Mother's Bahraini, father's Dutch. They lived in Holland, and then prior to the hearing in London, which is why I was here. The father wanted to take the children back to Holland. Mother wanted to stay with the children in London. Father's application refused, so outcome, mother to stay with, children to stay with their mother in London, but 6 months later, father's still in Holland, and mother's gone to Bahrain with the children. And what had happened in that case, there was no indication, she was my client, no indication, certainly to me during the proceedings, that she had this in mind, and as far as I know, she was genuine. But afterwards, I don't know what her thinking was, but what I do know is that he just couldn't face or afford another round of litigation, so he really had no option. When she said, I want to go to Bahrain now, he said, okay. J. New Zealander father, American mother, in the UK for about 5 years. Mother wanted to go back to the States with the children, father wanted to remain in London. For various reasons, the final hearing took place and the outcome was adjourned for a year. Slightly complicated and I won't go into why, but what happened in the meantime while it was waiting for a rehearing was that mother meets a new partner and then decided to stay. Last one. Parents both British, so unusually an entirely British family. Mother meets a new partner, job in Germany, application to go to Germany, father says stay here, application is granted, as they often are, these ones based on a job. 6 months later, job hasn't worked out, mother, new partner and children all back in the UK, but by that stage, father had thought, oh well, no point me being here if she's going to be in Germany, so he had gone to Dubai. What am I trying to say when I tell you about these cases? It's obviously just anecdotal, but these are some suggestions. One is people's plans and intentions do change. They aren't always fixed, especially perhaps when people are recently separated and struggling with all the emotions that come with that. And things can look really different not that far down the line. The passage of time affects obviously the way people feel, but also stuff happens. People do get jobs, people do meet new partners. That sense of isolation after a breakup may not last as long as the client thinks. The other thing is that, especially in London, people do live quite international lifestyles, so just because they've lived in London for 2 years doesn't mean that either of them are actually going to be here in 2 years' time. So we run these cases on the assumption that where people are at the moment of trial is where they're going to be for the foreseeable future, both emotionally and geographically. And actually, when you look at many families' backgrounds, is it really likely that they're going to settle and stay put? So what I'd like to think about is whether we could be doing more for these parents, instead of launching them straight into the litigation and going down the binary route, to see whether an outcome can be reached which is more likely to be sustainable and which isn't going to see everyone coming back or floating around the world 6 months later. So this is where mediation comes in. What does it offer? First of all, it's a better way, I think, of reality testing. A mediator can do this in a way that's quite hard for a solicitor to do, especially if you are shortly after a separation, you've got a client who's vulnerable and needing support. It's tricky to ask these sorts of questions of a client who really needs to see you as being 100% on their side. But a mediator can, and a good mediator will do it in a way that keeps the client on side and doesn't make them feel like they're under attack. And a mediator can reality test the other side too. Are you sure you want her to stay? If you have a father who's currently working in London, but perhaps hasn't got that many ties, that many roots here, is he really going to stay? If the whole family's American anyway, what are the chances of him going back home at some point in the future? And if he's going to, when might that be? And then the reality testing of the finances as well. It's painstaking work sorting through the costs of a proposed relocation because you're dealing in a different country and you don't have the information to hand. So for a solicitor it is hard, but it's really important it's done. And if you have a client who comes up with costings and the other side challenges them, mediation is actually a pretty good way of getting them to sit down and engage with the other's cases on that issue. And why is it a good idea to do this? Because there's nothing worse than your client ringing up to say how upset she is that you've won her case for her. And you may remember I think I called it the one who went to Canada. She got permission in December, and in January she and the children moved to some godforsaken part of Canada that's basically Alaska, right up the top. And rang up her solicitors to complain that everyone was miserable and it was too cold. And we spent a week, of course, showing the judge pictures of happy children building snowmen. So it really was a case where, during the hearing, she didn't have reality right in front of her like that. She was driven by all kinds of other things, as people often are, all kinds of emotions going on. And something had been missed, I thought, afterwards, in the process of preparation for that trial. Something that we could have done that we hadn't done. That could have prevented the situation that they all ended up in. So, reality testing is one. What else can mediation offer? Contact logistics. Now, this is obviously a really important aspect of a relocation case, and as the research does tend to show, too often contact arrangements break down after a relocation. It is, I think, almost always a good idea to send them off to mediation to see if they can agree, even on a contingent basis, so that if leave to remove is granted, you've got those arrangements in place. It can also be a good cover if you do suspect your client is a bit wobbly about it all, but they're not prepared to admit that to themselves, let alone to you. Once you've got them in mediation, they may be able to listen to the other side's perspective, and there may be scope for resolution of the whole thing. But even if it really is a head-to-head binary sort of case, the way to put this to clients, I think, is that the court just doesn't have time to deal with the really fine details of flight schedules and contact costs and dates. And often as well, it's left to the end of the trial when everyone is exhausted and highly emotional, and it's a really unpleasant process because nobody's giving an inch. But you can do it in mediation. I did one a few months ago when I was mediating, and we spent 2 full days, 8 hours each day pretty much, sitting around a table. But in the end, they got to an agreement, and I would put money on it actually working out, because during that process it became apparent where the likely pitfalls were going to be, and then they worked out what they were going to do to deal with them. And then thirdly, another advantage of mediating is you can come up with some creative solutions, the kind of thing that a court is never in a million years going to order. Sometimes there is something a bit like a middle way. You can postpone relocation for a couple of years. Courts don't do this because once they've got to the end of a round of litigation, no judge is going to want to leave the door open to another round in a couple of years' time. But if you haven't had that process, if you've avoided litigation and if you've still preserved some trust, then an agreement to a postponed relocation is possible. Unusual contact arrangements. There is a little girl in my daughter's class at school who spends her term times in London with her father, and every holiday, from the first day to the last day, in South Africa with her mother. Now again, no court will do that, no solicitor will advise that. We all say, oh, you need to share out the fun time, you need to share out the term times, blah, blah, blah. But actually, these parents agreed that when they separated, the mother got a good job in South Africa, they wanted their child educated in England, and actually it works. And then 2 country solutions, probably only for those families who are pretty well off. But there are parents who maintain a home in 2 countries and fly in and out. And I had one recently I came across who were doing a fortnightly share in term time. And one parent spent 2 weeks here and 2 weeks in the States. Again, no court's going to order that. All of these things are a bit mad. But if parents agree them and if it works for them, what does that matter? So if you think this might be a case where they might be able to agree something outside the court process that will avoid litigation, why not? Things to watch out for. These are a few perhaps contraindicators for mediating a relocation case. Mediation confidentiality is very hard to preserve in family cases, as I'm sure you know, because people just don't get it, and fair enough. It does lead to a degree of emotional dishonesty, and your client says to you, well, she agreed that she'd stay here and we were pretty much there, and then it fell apart on the division of the holidays, but she was all up for it, and how can she now turn around and say that the prospect of remaining in this country is so horrific she can't contemplate it for a moment? It is very difficult to explain that the mediation process is privileged and protected, but you do need to make sure that clients are fully aware of that, and the circumstances in which it may be waived or breached. So I've put a few authorities there. That's the only law you're going to get, I'm afraid. That's nothing else about the law in these notes at all. And then older children is the other warning sign that I would flag up, because there isn't much point in parents reaching an agreement if their teenager turns around and says, no way am I going to live in Wyoming, why would I want to do that? So if you've got older children and there is a disagreement, particularly a disagreement about what the children think, you are probably going to need not necessarily a court process, but some process of a neutral evaluation of the children's wishes and feelings before you can realistically reach an agreement that is likely to stick. And then finally, timings and delay. Aware of mediation being used tactically. We've all done it to exhaust the other side, emotionally or financially. Sometimes, especially if you are for the more vulnerable party, whatever type of vulnerability it is, you really do just need to get on an issue. So that's pretty much all I want to say. One final thought, all else aside, one really good reason why mediation is a good idea in any relocation case, whatever the circumstances. I was involved in an appeal last year. I wasn't involved below, thankfully, where an international relocation case had been heard over a week, 5 days. And you'll be thinking, well, that's good, you know, nice amount of court time. Don't get that very often these days in private law. No. This case got something between 1 and 2.5 hours each day, while the court simultaneously heard a 5-day care case. So morning care, afternoon relocation, sometimes swapping round, a few directions hearings along the way as well, judgment in the care case at 12 noon on the Friday, and in the relocation case at 2:15. We appealed it. Yeah, did you say poor judge? Yeah, I won't say sympathetic to the judge. Poor client. We appealed on, or tried to appeal on grounds of procedural unfairness. How can you hold all of those issues in your head at the same time? How can you do 2 cases simultaneously? And permission to appeal was refused at our oral hearing. So mediation must be a better alternative than that. And for the time being, while the Children's Arbitration Scheme excludes international relocation as an issue, it is pretty much the only alternative to litigation. So another good reason to keep out of the court system where you can.
Thank you very much, Madeleine. In my mind, I never thought that mediation would fit with relocation cases because they are so binary. You think, well, how on earth are they ever going to agree? But I think you've demonstrated that it's quite often the better way. And if people have made an arrangement through mediation, as we all know, it's much more likely to stick than if they've had it hoisted upon them by the judge with 2 heads. So, we've got 5 or 10 minutes now for some questions and answers. So we've got a roving mic there with Jenny. Does anyone have any questions to either of our speakers? Yes, maybe in the front.
It's actually not a question, it's more a comment that mediation is just the way forward in almost everything. And especially when I've had cases of children of different cultural backgrounds and different countries and, you know, everything different you can think about, it is the way forward, because thrashing it out in court is not the way forward.
Yeah, I generally agree with you, and that's a really good point about different cultural backgrounds. It doesn't even have to be anything as extreme as a different country or different nationality. Families do things differently, and you see that when you mediate. Yeah. They come along with a shared assumption that sounds wacky, but if that's their shared assumption,
it's their family.
That is their family, and it's much more likely to work out if they do things their way than in the way that the judge thinks is sensible.
Can I add something to what I think is a wonderful exposition of the sort of issues that you may have to, that you can explore in mediation, and one of them is whether or not the father left behind or the parent left behind can visit the country of relocation. Mm-hmm. And one of the things that you have to think about is, do they have a criminal conviction? Yes. Have they ever been refused entry clearance to any country? Because most countries have a visa application form that requires you to state that, and then you are going to be refused. If you're Bahraini, you're going to be a visa national in every country, so you're going to have to get a visa to travel as well as a visa to enter. And so you can have really significant difficulties arranging visits as between parents depending on their nationality or their immigration history.
Yes.
I just want to follow up on whether mediation's a good idea. MIAMs are often a box-ticking exercise, and the ones that get to court, you think, well, has anybody ever really discussed mediation with these people? There's nothing in part 3 of the APL, it requires a judge to say that he's reviewed or she's reviewed the operation of the mediation and is satisfied with it. And if they did and saw which boxes had been ticked and asked a couple of questions, they wouldn't be. Shouldn't we have a rule like that?
Well, there is that power to stay, and you're probably, yes, and you're probably right. It could well be used more.
A requirement in the rules that a judge must review the adequacy of the mediation process.
Yeah.
It doesn't happen.
Well, you can't force a mediation process as such.
No,
the most you can force is
from the Family Justice Review, we were very keen on this. Not so much that everybody had to mediate, but that the two individuals met a mediator to demystify what mediation was about, and hopefully a them would say this is something we want to do. And I don't see these cases now in the first instance, but my fear is that you're exactly right, that it's a box ticking, and by the time the case comes to the judge, no one even asks about the mediation
That is the case.
process. And I think what you're suggesting is quite a good idea, that there's a requirement on the judge to eyeball the folk at the first hearing or the second hearing and say, well, what has happened with mediation? Yes.
Another question from Madeleine. When you do have a proper mediation rather than MIAMS, what's your success rate? How many crack and how many have to go to a trial?
of these cases, particularly, or generally.
Yeah, relocation.
Yeah. It's difficult to answer because they come with different aims. So sometimes they come, quite often they come agreed that relocation will happen, so they're mediating about the contact arrangements. How many times have I actually mediated successfully from a position of no to an agreed yes? Twice that I can think of. I mean, out of I'm not sure how many, but yeah, I mean, not all of them certainly, and some of them won't resolve that way. But I think what it can do, even if you don't resolve it, is the flushing out some things by that route, the reality testing and the making sure. Sometimes the answer is yes, I really am sure on both sides, and then it should be litigated. Really, it has to be.
And what sort of, are they general mediators, or are they lawyer mediators, or are they dual mediation?
Or whatever works. And I've done them as a single lawyer mediator, but obviously there are a lot of pairs of more therapeutic styles out there, and that could be really successful as well.
Yes, that's the back.
Have you done any mediations where you've used a mediator from the country to which the relocation is going? To get the information, you've got somebody who actually has some idea of what the consequences will be.
No, the answer is no, I haven't, but I can see it could work. You've got to have a reasonable level of resources to do that, but then quite a lot of these cases do have a reasonable level of resources if they're global families anyway.
Might just be somebody who understood the geography and went to Canada.
Just a question for Kathryn. Do you think the whole Brexit and sort of thing is going to cause a massive conflict between the family and immigration side with movement of people and the children?
Well, I think there's an awful lot of things that are unresolved. Brussels too, for example. So a lot of the exchanges that we currently have, I think, are going to be more problematic. I think moving people around and assuming that you can move around, many of those things are likely to go. So I think it's a wait and see. But there's certainly, I don't think people have comprehended what it is to lose the citizenship. We are all EU citizens, and therefore we all have so many rights associated with that, and they're not simply movement rights, they're pension rights, they're anti-discrimination rights, there's a whole host of things. So I think in terms of resolving family matters, numbers of those other rights come into play, and so I think that you will see a very big change. Just this week we had another case on that Zambrano principle from the European Court of Justice, and that's enlarged the notion that that the child is the significant entity in terms of whether or not a parent can stay, And that principle of giving children the right to have a parent's day was such a revolution in immigration law. Children were always dependents on parents, so they had no right ever to allow a parent to derive residence rights from them. So a lot of those principles might go, and I think it would be a great shame if they do, in terms of the way in which we've come to think about children and their identity and attachment rights and so forth.
Yes.
It seems to me that there's a real issue about local authorities being aware and having the knowledge in terms of regularising a child's nationality and getting a child British citizenship before they get to 18. And that in a lot of local authorities there just isn't that expertise that is there. And there are another category of children, the children who are placed under special guardianship orders, that nobody makes that provision. So what you were saying about what ought to go into care plans in respect of those children must be very important and will become even more important if we Brexit it. And that must be an area of concern that ought to be addressed, and both the local authorities and the courts need to be very well aware of that.
I just really, I think the other thing that, because I did some of my law in Australia, one of the things that you see now with numbers of particularly Roma children is that where you get these children taken into care and where you're thinking about placements, the idea of it's not simply, I know the courts have considered issues of identity and attachment, but there's also another issue that you see in countries like Canada, Australia, New Zealand, where you are effecting a sort of cultural genocide by removing so many children from a community and placing them in families where they don't have a congruent culture in growing up. And the care proceedings in a lot of those countries have very explicit provisions that require a matching where you've got an issue of cultural genocide. And the Roma Rights Institute in Prague has certainly begun speaking with lawyers in this country to get them to think about how do you address those problems that you see in those countries where you get so many children from a particular ethnic group removed and placed in families that are not consistent with their culture, and where you end up having then the Australians refer to and Canadians refer to the stolen generation or the forgotten generations, where they really have difficulties in young adulthood. So I think those sorts of things are also waiting in the wings here in terms of our notions of how children are moved and placed.
One last question. We've exhausted you. Well, I hope you'll stay for a drink and a nibble. I don't know what you think, but I feel that an event like this, which lasts about an hour or so, where we take two quite narrow but specific topics, is quite useful. And if you've got ideas for other topics that Bloomsbury could put on, I'm sure they're up for it. Not Jenny's recovered from organising this one, so do put that on the feedback form. Any ideas would be very, very welcome. I think one thing, well, a number of things come out of this, but I think your point about Brexit, right, there's certainly going to be less cases where there's a crossover between what we're doing in the family law side and the immigration side. And the point that comes across to me is that where things go wrong is where one side of the case, the family law side or the immigration side, isn't really communicating with the other way, whether it's the courts not communicating with the tribunals, vice versa, or the lawyers, and you only realise that it's going wrong when it's too late. And so I think the more we can do to understand, with the help of Kathryn and others, the immigration side and vice versa, the better. And the guidance that Nicholas Blake and I put out was important in the sense that it was the first time anybody had tried to have a go at it, but I don't think it's necessarily the be-all and end-all of it. But that was aimed at getting the tribunal and the court to talk to each other. So I think we just need to be even more clued up about this than we are. But tonight's helped, I think, both on that topic and on mediation. So thank you for coming, and thank you to Kathryn and Madeleine for giving us all that information.